All, welcome to this channel. Today's video is about the 16th presidential reference made by the President of India. Nearly 14 questions were asked by the President of India. Okay, so after the Supreme Court has answered 11 questions, so 3 questions were not answered by the Supreme Court. They just denied those questions. They said it is irrelevant to this topic. So let's not see about those left questions. Let us focus on these 11 questions asked by the President. So Supreme Court has given the answers. So it is regarding the Tamil Nadu governor case of giving assent to the bill under Article 200 of the Constitution. So why we are seeing this particular article in the sense, it is because there are numerous articles being referred in this case. It is not a case actually. It is not an override of the previous judgment also. It is just the questions referred to the Supreme Court by the President. Those questions has been answered with the clarity and clearance. Okay, so we're just gonna see those questions and what are the articles mentioned, what were those governor's powers, and all about the judicial law, like Article 142 of the Constitution to ensure complete justice. Judiciary has performed its. It is not a judicial overreach. So okay, let's see about the articles. So under Article 200 of the Constitution, governor has three. Previously we used to say that governor has four options under Article 200 of the Constitution. The first thing is governor can give assent. He can give assent to the bill. He can withhold. He can withhold the bill, and he can return the bill back to the assembly, and he reserve it for the president table. This is under the Article 201 of the Constitution. Okay, so now judiciary has answered for this question that the governor has only three options. It is not four options, it's only three options. One is giving assent, and the second thing is withholding the bill and returning the bill. Actually these two comes under one option, and the third thing is reserving it for the President of India, President's table. So nearly Tamil Nadu governor has placed nearly 12 bills, I think 12 bills under this provision of Article 201. So it clearly Supreme Court has said that it is for delaying the bill. The governor has, they just mentioned the word, it is sitting. Governor is sitting on the bill for a prolonged time without giving a proper reason. He's sitting on the bill. Actually this bill was returned by him to back to the state legislative assembly. So under constitution, if a governor is returning the bill to the assembly, then again with or without its recommendations, the state legislative assembly is passing again to the governor's table, that the governor has to sign. On the second time he has to sign, but he has reserved the second time bill to the president's table. So it clearly mentioned on the case itself, which was given in the April 8th. So I'm repeating it again that this particular presidential reference does not affect with the judgment given on the case, because on the judgment the Supreme Court said that all those bills are deemed to be assent. And it also mentions that within, actually under the Constitution we have to say that, so wait a minute, so I'll pick a new thing. So under Constitution it's clearly mentioned that the governor has to give assent as soon as possible. There is no time frame mentioned in the Constitution. Okay, under Article 200, the assent to bill is as soon as possible. No time frame has been fixed. So in this case, Supreme Court has mentioned the time limit for the governor giving assent to the bill, which is 3 months. So now the president has asked the question that can Supreme Court fix the time limit for the executive, which means for the president and for the governor. They are coming under constitutional post, right? And also they have um, the president has asked about the article 361. And what about article 361? President and governor has some special power which they will not be coming under the article 14, because article 14 says that all are equal before law, but article 361 gives some special power to the president and governor that they're not liable to the civil and criminal proceedings. I mean, they're not liable to the criminal proceedings, but civil proceedings can be taken against their post. Okay, if they are violating against the constitution, if the post is what they're working is violating against the constitution, then the civil cases can made appeal, but they are immune from the criminal thing. Okay, so this was asked by the president. The Supreme Court has answered for this question also, that this 361 article is only a personal one. It is only for the personal thing, not for the presidential office or the governor office. It's not for your office, it's for only for the post. Okay, so this was given by the Supreme Court, this answer about the article 361. So on exam point of view, we have to note it about it. Article 361, it is only for the personal, not for the presidential or governor's office. And for this time limit, can judiciary fix the time limit for the executive for approving the bills? So this was also answered by the Supreme Court, that allocating the time or framing the time for the executive by the judiciary is not allowed. So this 3 months is not correct. So Supreme Court has said that this 3 months. And so this was the another question. And another one is, president has asked that actually under article 145 of the constitution, article 145 is the rules and procedure of the Supreme Court. Okay, rules of Supreme Court. In this, actually, if president is asking a referential question under article 143, which is advisory jurisdiction, then the Supreme Court seating of the judges bench should consist of minimum of 5 judges and maximum to the half of the present judges. But the previously mentioned cases about the governor, the sitting was only a 2-judge bench. It is only a 2-judge bench. But now, with respect to this presidential reference question, the answer was given by a 5-judge bench. So this was also answered by the Supreme Court. So the another thing is about article 163. Does governor do not contain any discretionary power for him? I mean, under situational basis, not constitutionally, but only under the situational. It is a situationary discretion. Okay, it is situational discretion. It's, we all know about it. But if in the examination, if it is asked that governor has discretionary power and article 163 means it is correct. Okay, so this is one thing. So the Supreme Court also said that governor has a discretionary power. And the next question is that actually in the parliament or in the legislative assembly, wherever it is, when a bill is being passed and becoming an act, the copy of the act has to be sent to the Supreme Court for the case of Parliament, and if it is in the case of assembly, the copy of the act has to be given to the respective court. So now what president has asked in the sense, the governor actually didn't act on the what actually happening, it is the bill here, it is only the bill. The governor's case is regarding those 12 bills. It is only a bill. It does not become an act. Only if it is becoming an act, and if it is against the constitution, only at that time can supreme court can come and question. But can supreme court can extend its power of Article 142 even on the bills present in the parliament or in the assembly. So this was asked by the president, and Supreme Court has answered that no, the Supreme Court cannot extend its jurisdiction over the bills present in the legislature. No, this is not correct. So these are the answers given by the Supreme Court. But the thing is, only the acts can be interfered by the Supreme Court under judicial review. That can be taken under the judicial review. Okay. But they also mentioned that if a particular bill is not, actually it is clearly mentioned that governor doesn't have pocket veto. He has suspensive veto, but no pocket veto for governor. If he is not acting anything on the bills, if he is simply sitting on the bill for a prolonged time intentionally, then the judicial review is allowed. Even on bills also, the judicial review is allowed by the Supreme Court. If the governor or if the executives are intentionally sitting on the bill without taking any action, then Supreme Court will question. The interference of Supreme Court can be allowed, and it is subject to the judicial review. So this is the thing which was asked by the president, and the referential precedent of questions made by the president was answered by the Supreme Court. Out of 14 questions, 11 were answered. So this also you have to note it about it. And this is the 16th presidential reference, and make a note of it. Before that, there are 15 references. No need to note about it, but on no need for exam basis. But you can just see what are those questions made. So these are the articles. So I will write once again those all articles referred in this case. So we have to article 200 of the constitution, article 201 of the constitution, it is giving assent. It talks about the president. So kindly bear with my handwriting, I'm sorry. It is with the president's reference. And article 143 is advisory jurisdiction. Article 145 is about the rules of the Supreme Court. So these rules and procedure is only can be done with the approval of the president. Okay. So an article 163, which is governor's discretion, only in situational basis, situational discretionary power it is. Okay. An article, the main article is article 142. Supreme Court can extend its power to ensure complete justice. And article 361, which is the immune, president and governor are immune from criminal proceedings. This was answered by the Supreme Court that this criminal proceedings is only for the personal ambiguity, not for the office of the governor or the president. Okay, so these are the articles mentioned. So give it. So just make a note of these articles, and I think I've given detailed explanation about this thing. If you have any doubts, you can ask me in the comments so that I can reply. So thanks for watching this video, and thank you guys.